And so, you know, we talked about this. We were kind of at the midpoint last year of talking about the impeachment proceedings, and you'll recall it started with the investigation and the fact that the desks were missing from the Capitol, and then just snowballed from there. And unfortunately, as we see from this clip, we got national news that didn't look very good for West Virginia. And reminding you of the controversy, you know, a lot of spending on renovations, personal use of vehicles, this issue of paying retired judges in excess of statutory amounts. And so this thing kind of steamrolled. And you'll recall that Justice Lawfrey was charged, indicted. Ketchum and Davis retired immediately prior to the in which their seats would go into an election. So that if you have a review of the whole thing, this is the impeachment timeline. So I'm just going to let you just take a look at this for a minute, and you'll see where we are. You walk over, and it shows, you know, Justice Lawfrey goes off the court, and that was kind of the last piece of the impeachment. And then you had the appointment of Justice Hutchison. So we have a full court for the very end of the last term and for the January term. So, you know, you'll recall there was, when Justices Armstead and Jenkins were appointed, there was a suit claiming they were not qualified, brought in the Supreme Court. And one of the oddities of this whole thing is, I think at one point we counted there were seven separate Supreme Courts because of the recusals and the replacements with circuit judges. And so that case came down and dismissed that challenge against them. You know, we went through the impeachment. Justice Walker was the only judge that proceeded to impeachment and was acquitted after, I think, a day or so of testimony. And then we come to the State ex rel Workman versus Carmichael case, which is the case that Justice Workman brought challenging the impeachment. It's Mr. Williams who's involved in that case to comment.
I would like to say that now, a year past when all this happened, that we are beyond the impeachment issue, and we can look back and maybe see if there are lessons that can be learned. Unfortunately, that's not the case, as you'll see in a minute. There is an appeal to the United States Supreme Court that is still pending. But the writ that was filed and was heard by this group of circuit judges, we predicted last year in this presentation that there were issues like that. Now, none of us were involved in those cases at the time, but it was clear that the House was moving towards the process of voting for impeachment. An investigation had commenced. I think it was the state auditor's office had issued a report, and there were some serious legal questions that needed to be determined. And the reason that we took on this matter, and Melissa Foster Bird, my partner who worked on that brief so hard, is here as well, was because there are significant questions that we thought had to be resolved regarding the authority of the judiciary and the authority of the legislature as it relates to impeachment. Now, there were a lot of interesting syllabus points that came out of this decision, but basically what it boils down to is whether or not, if there are things that under our Constitution that are given exclusively to the control of the court, and if you recall, prior to the passage of the budget amendment in last November, the Supreme Court had exclusive control over its budget. They would present to the legislature each year what they wanted for the judiciary's budget. It's a unified budget involving all courts. And at least up to that point, the legislature was obligated to fund it. And there were lots of decisions that had come up over the years about the exercise of line item veto on the judiciary's budget, et cetera, where the court said separation of powers means something. There is a provision in our state constitution that provides for separation of powers, very different than what the U.S. Constitution says. And under those circumstances, it was ripe for that issue to be put before these 5 circuit judges that heard this decision. They issued a very long opinion and ultimately determined that there were some procedural defects in the way that the impeachment proceeded, and that some of the impeachment articles violated the separation of powers. Interestingly, the court did not address the question of whether or not the excessive spending violated the separation of powers relating to the exclusivity of the judiciary over its own budget. What they did decide was that the statute that says that you can't pay senior status judges more than X violates the judiciary's ability to control that portion of compensation for judges that in their mind have to be taking on matters in order to make sure that courthouses are open and justice is served. The other interesting point was that there was an omnibus provision in the impeachment that said all the justices violated certain canons of ethics. And under those circumstances, that constituted an impeachable offense. The court held that the Supreme Court of Appeals has exclusive authority over the determination of whether or not judges comply or violate the canons of ethics. So interestingly, that article of impeachment would not have violated the separation of powers if it had just said that the excessive spending constituted maladministration. It was only by referencing in the violation of the canons of ethics that made it problematic. So where are we today? Well, I know that there are a lot of people in the legislature that don't like that opinion, as evidenced by comments and the appeals that have taken place since then. What I can tell you, though, is that this opinion does not say, and it was never intended to say, that impeachment of judicial officers cannot take place. In fact, the issue that's in front of the U.S. Supreme Court now is whether this case falls through a really narrow hole where judicial intervention of impeachment is possible. And that's basically what we had said all along in the briefing, is that there were a narrow set of circumstances where impeachment would be subject to judicial review. But to the extent that anyone says that this prohibits an impeachment of a judicial officer, that's not the case. And that opinion can't be interpreted that way. Now, after the opinion was issued, Justice Workman and Justice Lawfrey tried to, who had not joined in that effort before, tried to get in on the impact of that decision. And for reasons that are way inside baseball that we're not going to talk about, when the Carmichael decision was issued, the court issued immediately its mandate making the opinion effective. And that became important because subsequent efforts by the House to intervene, the Senate to move to reconsider, were denied because once the mandate is issued, the case and the opinion is official. So it goes now to the United States Supreme Court, and it will be heard on October 1st, the first day of the new term, when the appeal of the House and the Senate on a writ of certiorari will be heard by the U.S. Supreme Court, and we hopefully will know shortly thereafter whether or not they've accepted the case.
So we know on October 12th, Justice Lawfrey was convicted. Justice Walker was then elected Chief Justice of the court, and we went to the nonpartisan judicial race, which, as you may recall this slide from last year, and some of my friends who ran in that race, I think, would agree with that slide. We had 20 candidates, 10 candidates for each spot. Sounds a lot like the Democratic debates, but which are equally as big a mess, I think. So Justices Jenkins and Armstead were elected. So you start having the pieces of a full court put together, and then Justice Lawfrey finally resigns, which he had been called upon to do, I think, by the chamber much earlier than that. And we bring Justice Hutchison is brought onto the court. So the fall term of the court was really abbreviated. Typically you have oral arguments starting the first week of September and going through until, say, December. All the oral arguments were canceled until I think they did, and we'll talk about, they just did a couple of cases, but largely had no oral arguments in the fall 2018 term, and they typically have 7 or 8 sessions of oral arguments. So that was unusual. I will say this, if you were worried that the court stopped working, they didn't. They issued 256 opinions, which is pretty much par for the course in terms of the grist of the work of the court. And as you all recall, a lot of memorandum decisions that are not judge written, so in the abuse and neglect and criminal cases and other things. So despite the turmoil, the court continued to work and they had a couple of interesting cases. And I think you doing sore loser?
Yeah, the first case was the Don Blankenship trying to get on the ballot for the Constitution Party after having run as a Republican in the primary and losing. That opinion was issued the day of this presentation last year, you may recall, and the court held that he could not switch parties and then having run as for one party in the primary, then switch parties and run for another party in the general, because there's a sore loser statute that West Virginia has that precludes that from happening. This is particularly interesting in light of the fact that Don Blankenship has announced that he has now switched parties again to be a Democrat. I don't know if you saw that. That was on social media over the last day or two, with at least some pundits believing that he is poised to run in the Democratic primary for governor if Senator Manchin were to run. So that will be interesting. If you want to buy Greg Thomas a drink, he might have some insight on that. But it'll always prove to be an interesting political season, especially when Mr. Blankenship's involved. Another important case is this University Park case, and it involves the question of whether or not any sort of construction that is done through a public-private partnership is subject to property tax. And for public entities like universities, Marshall, WVU, and the other state schools, and really any state entity, I guess, the whole concept of using partnerships between private money and public money is critical to the ability to expand, especially when you're talking about building construction. And this case is important because it made clear that for properties that were built in Morgantown, that they are not subject to property tax. So that is a good decision for developers, especially those that are endeavoring into these public-private partnerships.
And I meant to mention, you all recall that Judge Paul Farrell of Cabell County was appointed as Chief Justice to handle the impeachment and then remained on the court for the rest of the term. And despite, I think, a lot of folks thinking that maybe he might stay up there, he said from the beginning, I'm going to go do this job and I'm going back to Cabell County. So I want to talk about somebody that took on, that's one of those jobs that somebody called and goes, hey, what are you doing next week? And you might say, after you heard it, you say, well, I'm busy. But he shouldered that load. Endicott versus City of Oak Hill, not a huge case, but it's another case where the court found in favor of a police officer who was sued when someone was involved in kind of tangential to a police chase. And the law in that area is a much higher burden for plaintiffs to sue governmental agencies and police officers. And so this is kind of an indication that the court is going to continue to look at those kind of cases conservatively. Of course, we changed courts as of January 1. There's 3 cases that are interesting, and utility cases are not interesting. All right, so you just glaze over. I'm not going to go on about these. But in these 3 cases, Jefferson County Citizens, Ohio Valley Jobs Alliance, in the Pool case, all involved separate decisions by the Public Service Commission. And in all 3 cases, the court deferred to the Public Service Commission. And the significance of that is, and this is a much bigger issue on the federal level, but in terms of state law, at least these decisions would suggest that when you litigate something and a regulator makes a reasoned decision on the record, that the court's going to defer to those decisions. We talked about 3 cases that were pending rehearing last year that were delayed because of all of the shenanigans up at the court. The court affirmed a case that held that the business court could offer arbitration if the parties agreed to it. and that case sat for a while because of all the impeachment stuff. And I say they affirmed, the plaintiffs in each of these cases sought rehearing, and the decision on rehearing was delayed. They refused rehearing in the innovator liability case, which is, we got national attention for that case, and it was a very significant case for West Virginia. And the last one that's interesting is we've talked to you about this trend, and we're going to talk some more about the court's deference to arbitration agreements under the Federal and State Arbitration Act. And they refused a petition for rehearing in the Shanklin case, which we discussed last year, which affirmed that you can have an arbitration clause in a nursing home agreement that would force, if the resident of the nursing home is injured, they would have to comply with the agreement and go to arbitration. So that's a pretty significant decision as it relates to arbitration. And as we jump around, Justice Hutchison's appointed December 12th, and we launched to January 2019 term with a full court, which was a good thing.
And think about how different the court is at that point compared to just a few months earlier. You have a new Chief Justice with Justice Walker taking over as chief. You have 3 new justices. Justice Hutchison elevated from the trial bench in Raleigh County, Justice Armstead and Justice Jenkins, both coming out of legislative history or experience to go on the bench. So it's a new court. They had a bit of a time where they were sort of getting their sea legs under them. But what we wanted to give for you was an analysis of how this court is different than other courts that we've seen over the last couple of years with this much changeover. Justice Walker and Justice Workman continued on, but in the Chief's chair was Elizabeth Walker, who's taken on responsibility for trying to rebuild the trust from lawyers, from the public, and probably more importantly, from those in state government, from the governor and from the legislature. And they've worked really hard at that. But they also had a very productive session involving some really critical and important issues that are decided in a way that I don't know that I could have predicted they would have been decided in the past. One of them was this issue regarding third-party administrators in a workers' comp. In basic claims handling and workers' comp, it's not uncommon for a company to hire a third-party administrator like Gallagher Bassett to administer those claims. And in this case, there was an attempt to claim workers' compensation discrimination against the third-party administrator, and the court said no. This is important because this is consistent with holdings in other states. What we're seeing in this opinion and some others we're going to talk about is that the court is more likely to follow the trends of our other sister jurisdictions. And we are being less of an outlier on important issues. And an important one, well, actually, it's not this one, it's one coming up. Tom will handle this MPLA case.
So 2 points. We've always had a big slide that said 3-2. So you can tell when you look at these opinions that having a 3-judge majority matters. What's interesting to me is, and we'll have to, we're going to have potentially a different court in May. What's interesting to me, and I haven't got my arms around it, is all of the justices are not voting the way that you might predict they're voting. And so there still is some secret sauce to being on a court, that you see 3 justices voting a certain way, and you think, well, that's surprising, and then sometimes you think a little further, and it's not so surprising. So Smith versus Clark is an important decision for doctors. And we've had a number of these. There's probably been 16 cases up on the requirement that you give a notice of claim and a certificate of merit, an affidavit of an expert you have to send to a doctor before you sue them. The statute's very clear on that. And we've had a number of decisions, the end result of which is that even if you win that the party violated the statute, they get an extra year to fix it. So you get your win, and then you got to wait a year and hope the case goes away. This case, well, actually, I jumped ahead to another case. I apologize. Smith is the case. I'll go ahead and do that, and when we get to it, we'll skip it. They affirm the dismissal of a case because they violated the statute. And if you're a doctor or a hospital, that's important, because if you don't satisfy the statute, then it gives the trial judges the authority to throw those cases out. The Smith case, which I got confused, sorry, it's the 4-hour delay in getting our talk going, as did it. This
and
this
the 2 shots of vodka.
Yeah, we're drinking vodka up here. So this case is it's a little inside baseball, but you got a defense verdict in a case for a doctor, which isn't unusual. Any stat you look at in the last 40 years, doctors win 6 or 7 out of 10. But it's really important because the plaintiff said that the doctor could not testify that he didn't breach the standard of care because they had an expert. They said it would be multiple testimony, that's not fair. And the court held, look, a doctor's entitled to get up in front of a jury and tell him he didn't do anything wrong. And that's important. Anybody that tries these cases know that a jury wants to hear the doctor tell them what they did and why they did it. On the other side, the plaintiff tried to call 2 experts, and they excluded one of them because it was duplicative. And so maybe that's not much balance, but there's a really interesting dissent because there was an issue about whether one of the jurors should have been disqualified, and Justices Workman and Hutchison took issue with the failure to exclude that juror.
Then there are a couple of decisions that deal with litigation relating to mineral extraction in the oil and gas industry. And 2 really important cases that address this that are sometimes hard to reconcile because they go in different directions. One is the Andrews versus Entero case, and was a question of whether or not fracking could be contemplated under a lease, and because of all the associated problems with living in proximity to that, the plaintiffs, and I believe this was a class action if I remember correctly,
came out of mass litigation. Well,
we're trying to get the court to adopt that the fracking was not contemplated under the lease and thus should not be allowed, and the court said no, it would be contemplated and it should be allowed. So that was good, a good decision for the oil and gas industry in terms of development. Now, the other side is this EQT case involving the drilling where the pad is on one person's property, but because of the nature of the drilling will go under somebody else's property. And whether or not that's reasonable under the circumstances, that if you have a lease for surface rights to go on and disturb surface rights for the purpose of oil and gas drilling, and you actually are drilling under not only that property but also an adjoining property, whether that is violative of the lease. There was a trial with a verdict, and the court found that that's not allowed under those circumstances. And I watched the argument for this case. It was argued for EQT by a very smart oil and gas lawyer from a large firm in Pittsburgh. But it was clear to me that the court and the lawyer were like 2 ships passing in the night. The lawyer was relying upon this provision of the lease, and we quote it in here, that says they have the right to use surface operations in a reasonable manner, in a reasonable and necessary. Was it reasonable and necessary? And I bet in oral argument, reasonable and necessary was repeated at least 100 times. And the court kept drilling down with this lawyer in oral argument to say, let's talk about whether or not this is reasonable and necessary under the circumstances. And they never really got to that point. So I was not necessarily surprised by the outcome, because I could tell that the court was struggling with that issue at oral argument, and ultimately that became the determining issue in the opinion.
They probably should have hired a West Virginia lawyer.
Well, you know, that's an interesting question. Is we get this asked a lot, those of us that do appellate work, is whether or not you are better off having West Virginia counsel argue the cases. And we would have every reason to tell you, oh, hell yeah, it makes a difference. I'm not so sure it does with this court. There are previous courts, however, where I think it did make a difference. And there were certain justices that didn't like it when lawyers from Richmond came over and would quote Virginia law, and they would have to remind them that this was West Virginia, not Virginia, that kind of thing. But for the most part, this court is working really hard to do things the right way, show respect for advocates, make the right decision. And while we may disagree sometimes with the decisions, the reasoning that they're setting out makes some sense to us. So, and that is a good thing. That a level of predictability is what we hope we find in these courts.
So I'm handling all the procedural cases because I get excited about procedural cases. So, you know, you can go up, if you have a final order, everything's done, you can appeal, all right? Short of that, you have to go up on what's called an extraordinary writ. Either a writ of mandamus, that they're not doing something that they absolutely have to do, or a writ of prohibition, that they're doing things they shouldn't do. You see much more in terms of a writ of prohibition. What this court has done is to make very clear to litigants the kind of record that you have to come to the court on an extraordinary writ. And that's a good thing, because extraordinary writs should be rarely granted. All right? Most courts want you to finish the case, have an appeal, and let them decide all the issues. They don't want things coming up piecemeal. So what this case says is, look, if in an order denying summary judgment, which is never a final order because it denies a motion to dismiss the case keeps going, that a judge doesn't have to give a bunch of findings. He can just give a general order that says, I deny summary judgment. And that defers to circuit judges who have crowded dockets and are hearing all kinds of cases and all kinds of motions. But what it does say is if you think the judge is wrong, you have to ask them to enter an order denying your motion that has findings of fact and conclusions of law so that the Supreme Court can adequately evaluate whether to issue a writ. And that's a good ruling. In that case, they found because there were no findings that they couldn't decide it, so they dismissed the writ. And I will tell you from personal experience, when you say to a judge, a circuit judge, I'm going to need findings of fact and conclusions of law because I'm going to the Supreme Court, they usually say something to the effect of, take your best shot, Herney. Our favorite issue.
My friend Judge Tabbitt said, I hope you're not going to talk about any of my cases. And I said, well, we just have one.
Just one.
Just one. For any of you that have attended this in the past, one of the things we beat on for more than 2 years is the fact that our class action jurisprudence was out of whack with other jurisdictions. You could take a class action case, and file it in federal court in Charleston, and it would not be certified, and take the same case across the street and file it in Kanawha County, and it would always be certified. And I'm not being critical of the judges, it was the state of the law. Now, in the U-Haul case, which was a memorandum decision regarding a consumer class action matter, Judge Tabbitt found and was affirmed that notwithstanding the fact that there were individual facts that would have to be proven to show whether or not the plaintiffs were injured, that as long as there was a single common issue, that was sufficient for commonality under Rule 23. Well, our court has not addressed commonality in a signed opinion since the Reslin decision, which was 20 years ago? Yeah. Written by Justice Starcher, to tell you how long ago it was.
Back when Judge Hutchison was new to the bench, I think.
Well, and it came out of Raleigh County, as he reminded me in oral argument recently. But Reslin made it extraordinarily easy because the standard was so low for certification of a class. And we're increasingly seeing class actions filed. They're the most popular form of litigation that's being filed now because the plaintiff's lawyers recognize that you get more money from class actions than you do from a single incident lawsuit. And so for those of us that do class action work, we've been fighting this battle of trying to get the interpretation of our Rule 23 to be more similar, is that a word? More in line with the federal Rule 23. And the Supreme Court issued a decision almost at the very end of the term. It was argued in February, but the decision, and it was supposed to be a memorandum decision when it was argued, but it ended up being a signed opinion that they issued the last week before they adjourned. And that's State XRL WVU Hospital versus Gilbert. And the most important decision out of this is that for the first time since Reslin, they have addressed in a signed opinion the question of what sort of facts have to be present. There are 8, I believe, new syllabus points in this case. They have adopted the U.S. Supreme Court's decision from the Walmart versus Dukes case on commonality. They have made clear that you actually can look at the merits in deciding whether or not a case should be certified, which the Reslin decision said you could not. So this is a critically important case in showing our courts, our trial courts, that they have a little more flexibility in analyzing these cases and making determinations as to whether or not the requirements of the rule are fulfilled. So I think this is a real important case, not just because I do a lot of class action work, but because it is such a dramatic step in the right direction.
So Mark, would you mention who wrote the opinion and what the vote was?
The vote was unanimous, and it was written by?
I thought Walker.
I thought Walker,
I thought
right?
Walker did it.
Yeah.
Yes.
Chief Justice Walker wrote the opinion, as I recall. Yes.
So let me say this to you. The thing about the class that's so important is that if you handle class actions, once a class is certified, in other words, that the plaintiffs who sued represent all similar folks, there's immense pressure on the defendants to settle. And so when you're handling class actions, I mean, class certification is the battle. Because if you lose class certification, all of a sudden you go to a trial, you're not losing a case against one person, you're losing it against potentially, 150,000. And so they get very complicated. And in fact, if you research jury verdicts in class actions, there's not that many of them. Because these cases tend to settle because of the immense pressure put on defendants because of the risk of losing a case to a class. So to the extent our circuit judges are equipped to take a closer look at class action, it makes us more consistent with the federal and other states, but it also means that the hurdle to before you can put that immense pressure on the defendants is higher, and that's appropriate.
Let me correct the record. Justice Walker did not write this opinion. She recused herself.
Yeah.
Oh.
She was recused, as was Justice Workman. Justice Armstead was sitting as chief in this case, and he wrote the opinion, along with two circuit judges that had names that were so similar that I was sure in oral argument I was going to get them screwed up. It was like Reader and Rotor. So, but the Gilbert opinion will be very helpful for those of us. The problem is, one of the problems with the case is they remanded it to Monongalia County for a redo on certification. So it is possible this might end up back in front of the Supreme Court again.
Certegy, it just continues real quickly. This is another case in which the court shows deference to arbitration. So if you sign an arbitration agreement, the court is going to, circuit courts, they're telling the circuit courts that if you have a valid arbitration agreement, people have to go to arbitration. What they're saying, though, is consistent with what I talked to you about before on orders and what they have to contain, is if a court denies a motion to compel arbitration, they've got to put findings of fact and conclusions of law in that order so that the party seeking arbitration has an opportunity to appeal or go up on a writ. So that's an important decision. This is a weird case, and I just put it out there because it's weird. If you get served with a complaint and it says you have 30 days or in federal court 21 days to answer and you don't do anything, you get a default judgment, which means you've admitted everything in the complaint, and then they have a hearing, most of the time in your absence, on how much it's worth, and then somebody shows up at your house with the judgment order. So default, if you remember one thing about default, it's bad. You don't want to be defaulted. Well, this is a really screwy case where there was an argument that they sued the wrong defendant, so the default judgment should not have been upheld. And the court examined it and basically found a close enough connection between the wrongly sued defendant and the defendant, and they also found that the defendant had many opportunities to raise this and never did, so they affirmed the default. If you feel like reading this case, you definitely want to read Justice Hutchison and Workman's dissent, because they really take issue with this idea that you could default an absent party, and they thought that there was, I read it in between the lines as a little bit of shenanigans going on below. But that's an interesting opinion, because typically courts don't like default. So I think this is I'd say this case is kind of a one-off, but it was weird enough that we wanted you to know about it. Daly is, I think Daly is a case that we're going to hear about again, because you know, typically if you sue a corporation, you get to sue the corporation. You don't get beyond them to the shareholders. You don't get to go from a subsidiary to a parent unless you pierce the corporate veil. And that's a pretty high test. And it is basically the way that courts respect the corporate form. So you invest in a corporation, you don't have somebody showing up and say, oh, by the way, we've pierced the corporate veil. In this case, the court found there were issues of fact that precluded summary judgment on the issue of whether the corporate veil could be pierced, and also for an issue of joint venture, which is two parties that join together and jointly profit from something. And so, you know, when you look at summary judgment under Rule 56, there's supposed to be no issue of fact. And if there's an issue of fact, court can't grant summary judgment. This opinion, in my view, is significant because if you do these cases and you're representing corporations, it's a little bit of a roadmap about how there could be issues of fact that preclude summary judgment. Because ultimately, you know, if you're the parent corporation or you are the owner of a corporation and you don't want the veil pierced, your avenue out of the case has got to be summary judgment. So that's a tough case.
And not only does it apply to piercing of the corporate veil, but it also applies to joint venture
Right.
claims. And that's where I think you're going to see it more often, where two commercial enterprises are engaged in some sort of commercial operation, and whether there is enough of a connection and sharing of profits and other information for that it would actually constitute a joint venture. That will occur in a case where you have one party, one defendant who does not have a lot of insurance, and another party who has a contract with them does have a lot of insurance. Plaintiffs' lawyers are going to be pointing to this case as an example of why you cannot get that joint venture claim dismissed, that you got to take it to trial. That's going to make it harder on businesses in litigation. Quickly, the Universal Underwriters case is another example of how our court is increasingly making the right decisions on insurance coverage matters. There was a time, not so long ago, that our courts would generally twist policy language to protect insureds, usually.
Yeah.
And in this case, it furthers the trend that we've seen over the last 5 or 6 years, where if there is plain language in a policy, it's going to be given the meaning that it was intended. And attempts to apply a reasonable expectations test, which basically says, well, I expected to have insurance notwithstanding what the policy language says, isn't going to apply. This is good for West Virginia in terms of how it is perceived among insurance carriers, because it hasn't been that long ago that insurance carriers just assumed that if they got engaged in coverage litigation in West Virginia, they would lose. When reality is, if the policy says something is not covered, absent some sort of other issue as to why you should in fact provide coverage notwithstanding that, you want the insurance policy to be read fairly. And this is a continuation of that.
So I'm not going to talk to you about the Maxwell government access to financial records, even though it is, trust me, one of the more thrilling topics that you would encounter at the chamber meeting this year. This case is important for one reason. Plaintiffs are always, the plaintiffs bar, and look, I don't say this stuff critically, but they're doing their job, is if they find a violation of a statute, they want to be able to go into court, go to a jury and say, I have a right of action because they violated this statute. There's a test that the court needs to apply to determine whether a private right of action is created under a statute. This is we've had a series of cases where the court has been very reticent to do that, and in this case they found there was not a private right of action under this statute. You don't really need to know about what the fascinating Maxwell Governmental Access statute is, but this one's weird. So this is a case, this is a case brought by families of miners who died in the 1968 Farmington mine disaster. Over the years, there have been two significant litigations, one in state, one in federal court over that. These folks filed a new suit saying, we just learned some new stuff about why this happened, and that means that despite the statute of limitations running, this was fraudulently concealed and we didn't know about it, so we ought to get a fresh shot at bringing a case. And what the court said was, no, the statute of limitations on a wrongful death case had run. What's interesting about the case is that they looked at the statute in effect in 1968, which I think limited damages to $100,000, if I remember correctly. And the court, in the interim years, there'd been some decisions, one of which I lost, that said that tolling doctrines apply to wrongful death. And the court said, we're not going to take those later decisions and then graft them onto a 1968 statute. So it was proper to dismiss the case. So there's some language in there that leads me to believe that there's some battles to be had on tolling doctrines and wrongful death. But interesting case, particularly since it went to that horrible tragedy in 1968.
I'm going to cover some of the labor and employment cases. I'll begin by talking about our right to work statute, which was passed in 2016. You might recall that Judge Bailey out of Kanawha County Circuit Court had entered an injunction and it sat for quite some time. She didn't make a decision. It went up to the Supreme Court. The Supreme Court said, you know, we're going to send it back to her. She needs to make a decision here, and it ought to be in line with our analysis. It sat for quite some time again. She finally made a decision in February of 19 and pretty much ignored what the Supreme Court said to her in their opinion, and so now that has been appealed up to the Supreme Court. Unfortunately, our Supreme Court has stayed her order, her permanent injunction, and I'm happy to tell you that the Chamber of Commerce and the West Virginia Manufacturers Association have filed amicus in that case. It has not been set for oral argument yet, though.
Do you expect it set this term?
Yes, I do. I'm going to cover these two arbitration cases fairly quickly. One is in a worker comp case, which is significant because what the employer had done was to say if there is a worker comp discrimination case, they had covered the kinds of cases that would be covered by arbitration. That was one of them. And the lower court said, we don't think that that should be covered. And the Supreme Court reversed and said that the delegation clause in the arbitration agreement controlled in the employment context. The next one involves a woman who had applied for a job at the Employee Resource Group. I can't remember the name of the restaurant, but anyway, it was a chain restaurant owned by this particular outfit. She had applied online, her training had been done online, and she had signed the arbitration agreement online through a digital signature, which, and they were a Kentucky outfit, and Kentucky has a law that says, that recognizes digital signatures. A lot of you may have used digital signatures in the past. In any event, the Supreme Court said that we're going to, and the court down in Williamson, West Virginia, had said they wouldn't honor the digital signature, and our Supreme Court reversed and said, you know, because Kentucky law allows it, we're going to go ahead and uphold the requirement that it go to arbitration. The next one is Woods versus Jeffords Corporation. And this fellow had applied for a job at Jeffords. He came in, he explained what his disability was. They went through various list of accommodations that they were willing to work with him on. They sent him to a physician to determine whether or not he was able to perform the essential functions of the job, and they had described what the essential functions of the job were. And it was going to require climbing on a ladder and other things that this gentleman could not do, and the accommodations were not something that would be covered by that. And when the medical opinion came out and said he can't perform the essential functions of the job even with these accommodations, they told him they didn't have a job for him. He argued with them for a little bit, and they said, look, we're going to rely on your physician. And our Supreme Court, with Hutchinson writing the opinion, said that an employer has no duty to second guess a reasonably independent medical opinion. And I will tell you that we've had a case where the employer got with the doctor ahead of time and said, if you discover any of these kinds of things, we don't want you to find that they're able to come to work for us, that they can perform the essential functions. So I warn you, do not do that. It really needs to be an independent medical opinion with respect to whether or not they can perform the essential functions of the job.
So we look ahead to the fall docket, some interesting cases. One of the first cases up is, the question is pregnant woman was killed, lost a fetus that was ectopic. And so we have a case that says that if a fetus dies, Farley versus Sarton, if a fetus dies, you can bring a wrongful death action regardless of viability. This is really a step beyond that, and asks, and it goes to this issue of whether just because the fact that you're pregnant. So I think it's a really interesting case. I'm sort of surprised it got up to the court, and it's a certified question from the Southern District. So the Southern District got this and lobbed it over to West Virginia. So they'll deal with that this term. And it's just an interesting issue, I think. Again, we've got another notice of claim, certificate of merit case being argued. I'll be interested to see where the court does based on the case I talked to you about earlier. We have a case about options to purchase. There's two cases up there where judges entered significant sanctions against defense counsel over discovery fights. And those, there's the Land Rover case, and then what was the other one?
The other one's out of Logan County, and they're both have already been set for argument. So if you go on the court website, you can read the briefs. They're fascinating descriptions of the conduct of counsel in the course of discovery, at least in the Logan County case. But I have a feeling that the court is going to, let's put it this way, I hope the court will utilize these two cases to make some strong comments regarding the need for civility among lawyers in litigation. Because at least, not in this case, Charlie King's case, but the Logan County case, the actions of counsel are troubling and problematic. And frankly, that lawyer who participated in troubling and problematic conduct was not the one that was sanctioned. It was the lawyer who was complaining about that lawyer's conduct, which is, I find, puzzling at best.
Okay, we're going to skip that one. All right, so we got to wrap up.
Yep.
This is you.
Yep. We put this slide up here to show the significance of what happens in May during the primary, because that will be what decides, or that election will decide who's on our Supreme Court. And as you can see, we've got the majority is up for re-election, or up for election, I should say. There are two 12-year terms and one 4-year term. This is a photograph of some of the people who have either run in the past and been interested, or who have been talked about as potential candidates. This slide gives you an idea of what the vote counts have been in the last couple of elections. And you will see that Tim Armstead, Joanna Tabbitt, and I think...
And the rest.
And the rest, yeah. And I bring those up because of the number of votes that they got last time. But you can see that Darryl McGraw got quite a number of votes when he ran, and we shouldn't count out that he might also consider a run this go-around. That's it. Do we have any thoughts other than I can see our other speakers are in the room anxious to get up here? Do you have a final thought?
The only other thing that I think we would add is that we think the court is moving in the right direction in a lot of respects. They're working hard to regain trust. They are making hard decisions on cases that need to be addressed, and the decisions are, for the most part, consistent with what we would expect, especially in other jurisdictions. And that, from our perspective, is a very good thing.
Yeah, I'd just say, the main thing that is important is that we have a predictability in the court. And so to the extent you're seeing some of these decisions that are consistent with other jurisdictions, defer to the legislature, defer to administrative bodies, I think you see the development of a law that is shows the kind of consistency that parties need to know in order to run their businesses, run their daily lives.
I was tickled to see the decision on class actions, and that it was a unanimous decision, and that there are 3 justices who are there now who participated in that decision. So I hope that continues.
Thank you very much.
Thank you.
first crossed.
Oh, okay.
So interesting kind of dynamics. This is how we first met. Brian was in Chicago. Right, he was in Northern Illinois. I was at UNC Wilmington. Okay. So Brian left UNC Wilmington to take the job at NIU.
Oh, okay.
I took his spot at UNC Wilmington.
So you're a scholar.
And we didn't even know each
So
other.
you're pushing it to the
I am. So I'm like, come on, guy. Come on, you know. So when I was interviewing for the actual position, Pat Leonard, who's still the vice president there, she said, Anthony, I want you to talk to someone, right, so you get a feel for UNC Wilmington, see if this is a good place. That's when I first spoke to her. That's when we first met. And then we crossed paths here again.
So we get a lot of cross
Right.
friends down
With the
around where I
actual-
well, Luke was Red. I just don't. He's been doing great. So you'll follow him.
Well, he's doing some good things. And I told him when I went down to his operation, I told him we walked into a really good spot. Radford today, when I was at Virginia Tech, Radford then compared to now, it's like the opposite side of the bed.
We need Gordon.
Okay, let me see if I can track him down.
Okay.
I don't have a cell phone for him.
I do.
You do? Okay.
Hey! Yep. You got it. If everyone will go ahead and take a seat, please. We'll go ahead and get started. We know we're running into the cocktail hour, so if you want to bring your cocktail in, that's all right with us. I don't think we have any objection. Thank you very much for coming to our session. My name is Robin Capehart. I'm the interim president at Bluefield State College. This is actually the third panel I've hosted at the Business Summit. I did it with 3 different jobs, so I guess I can't keep a job. I just keep moving around. It's my honor today to bring to you some of my colleagues for discussion. The title of it is Innovation and the Knowledge Economy. But when we spoke together, the 4 of us spoke together, we decided that we're going to be a little liberal with that type of with the topic, because we think this is a great opportunity to talk not just about that, but to talk about the future of higher education in West Virginia. I'm going to introduce our 3 panelists first, and then I'm going to ask them to make some remarks, and then afterwards what we really want to do is open it for questions so that we can have a discussion on whatever questions you may have. First of all, Dr. E. Gordon Gee is the president of West Virginia University. He's one of America's most prominent higher education leaders, having helmed universities for more than 3 decades. In 2009, Time magazine named him as one of the top 10 university presidents in the United States. Recently, the website Great Value Colleges named him the nation's top university president. He's the co-author of over a dozen books, including the 2 most recent, Leading Colleges and Universities and Land Grant Universities for the Future. Let's welcome Gordon Gee. Dr. Jerry Gilbert is the president of Marshall University. The 37th president of Marshall, Dr. Gilbert, is a Mississippi native with a background in biomedical engineering and research. He's led the effort to blend Marshall University's traditional focus on the liberal arts with its emerging strengths in science, technology, engineering, and health professions. Since coming to Marshall in 2016, his initial goals have included growing the institution in both size and quality through increased enrollment and retention, scholarly research, and doctoral programs, private donations, and marketing. He's also committed to leveraging higher education to help stimulate economic development in West Virginia and beyond. Please, let's welcome Dr. Jerry Gilbert. And our third panelist is Dr. Anthony Jenkins. He's the president of West Virginia State University. Dr. Jenkins began his path to West Virginia State University as a United States Army veteran and first-generation college graduate. He earned a bachelor's degree from Fayetteville State University, a master's from North Carolina Central University, and a PhD from Virginia Tech. Jenkins serves on several councils and boards, including the NCAA Division II President's Council, the Association of Public and Land-Grant Universities, Presidents and Chancellor's Council, Board of Directors of the 1890 Universities Foundation, excuse me, the Charleston Area Alliance, the West Virginia Business Roundtable, and the Rotary Club of Charleston. He's been inducted into several of the most prestigious academic honor businesses and leadership societies in the nation: Alpha Kappa Psi, Phi Kappa Phi, Sigma Alpha Pi, Alpha Sigma Lambda, Omicron, Delta, Kappa. There's no commas in this. Do you know that? They didn't put any commas. Alpha Phi Sigma and the Order of Omega. Let's welcome Dr. Jenkins. Ladies and gentlemen, it's really an honor to be here with these three. I don't think you're going to find three finer. I don't think there's a state in the country that can boast three more finer leaders in higher education than we have in West Virginia. So to begin and ask them just to say a few words, Dr. Gee.
Well, thank you very much. Everyone, thank you for being here, by the way. Is this thing working?
Yeah.
Yeah, I think it is. Well, I'm just going to try this. So, and first of all, Rob, thank you very much and for your leadership over many, many years. I appreciate it. And my colleagues here, I think we all are delighted about the opportunity to be here. And, of course, the summit is a way for us to all, I think, learn more about what is happening. I often comment that one of the things about West Virginia that is so wonderful is the fact that there are very few states, and certainly none that I think any of us have served in which you can get the business and community and political leadership and university leadership all in one place at one time, and I think that is such a great benefit. Of course, we are a small state, but that also means that there's only one degree of separation that makes life better. Innovation, creativity, curiosity, all the words that I think are terribly important for what we're trying to do in this state with higher education. The way that I think about it is the fact that there's 1.3 billion Chinese, 1.4 billion Indians, and although we are not in competition, we are. And the issue is a very simple one. That is, there are only 330 million Americans, and the way for us to continue to be competitive in the world is very simple, and that is for us to be able to continue to innovate and create. Because if we don't do that, if we try to do it on the basis of mass, we lose. And the opportunity, I think, is now for us and for this state to move toward a more creative and dynamic environment. And that is, I think, what the innovation economy is about and what our universities are about. So I really welcome the opportunity to be here, and more importantly, to know that that in this time that we are really focused on this notion of innovation and creativity, which I believe will make a difference over the next decade in this state. Jerry?
Thank you. I want to say that higher education has a critical role to help the state grow economically. We have a role not only in educating students, but also in stimulating the economy through what we're doing. We're committed to innovation and job creation at Marshall, and I think collaboration is the key. We need to collaborate with the Department of Commerce. We need to collaborate among ourselves as institutions, and we need to collaborate with the business people in the state to stimulate new jobs. We just released today a Marshall's Green Print for Growing Jobs and Talent in West Virginia, and it's called Advancing West Virginia. And just to give you a few things that are in this booklet that we just put out, we are looking at the role of our Brad D. Smith Incubator in creating new businesses in Huntington. We are excited that that's going to be an opportunity for people that are interested in having a business to come and have a place where they can start and have assistance from our College of Business in creating business plans. We have a new ICE Center in our College of Business, and that's Innovation Center, and it's looking at helping people develop business plans and be adaptive and be creative in creating new businesses. Also, our Robert C. Byrd Institute for Advanced Manufacturing has been involved with rapid prototyping, and we have assistance to businesses and business people that want to have assistance technically. We have helped over 6,200 different businesses through that center. We're also partnering at Marshall with the Department of Commerce to looking at an exploratory R&D trip to Japan and Korea this fall. We hope to connect with businesses there that might have interest in locating in West Virginia. And we've rolled out some new programs at Marshall. We have a new cyber security degree. We just got word today that Homeland Security gave us over $4 million in a grant to look at the dark web and how we can help prevent trafficking on the dark web as it relates to the opioid crisis. We just rolled out a biomedical engineering degree. We're looking at new degree programs in the technology area, as well as a new aviation program. And we hope to have aviation programs both in Charleston and in Huntington, both at the Tri-State Airport and at the Yeager Airport. RCBI has rolled out a new initiative called RCBI Aero. We got an I-6 grant from the federal EDA to expand the aerospace industry in the state, bringing industry into West Virginia, expanding our footprint. We've also been very involved in recovery efforts at Marshall. We've had a number of large grants looking at taking the workplace, those individuals that are addicted and may be outside of the work environment now, getting them rehabilitated, reintroducing them into the job market. We're also working with West Virginia State and 8 other institutions in southern West Virginia and the Alliance for the Economic Development of Southern West Virginia. We see that as a way to partner our schools in the southern part of the state and attract businesses. We've worked with a number of different companies already. We have a collegiate recovery program from the state that's rolling out through all of those institutions. So we're excited to be part of the solution of stimulating the economy for West Virginia.
Dr. Jenkins?
Thank you. And again, let me also thank everyone for being here and the honor to be up here with my colleagues to talk a little bit. Obviously, we all can talk about a lot of interesting and great things that we're doing in our respective institutions. And the list is very impressive. When I think about the innovation and the landscape of higher education in our state, I think of it really on 3 tiers, excuse me. And what are we doing at the national level to lift the brand and leverage what we do in higher education in this state? That is significant when you consider that young people around the world need to know more about the institutions of higher learning in West Virginia and what makes us better than anybody else, and why they should attend our institutions than the next state. That's an opportunity for us as we talk about all of these great things. It's how do we brand ourselves at that national and global level that we can compete with institutions in other states. I also want to challenge us when we think about innovation, when we think about these opportunities, is how do we also make sure that we don't forget that middle bandwidth and that low tier student and family that often gets left behind. When we talk about higher education, we have to be mindful that in the United States of America, that if you come from a household income of $30,000 or less, you have a 1 in 10 chance of earning a college education. And all of us in this room, bless you, know that there are households right here in West Virginia that make less than $30,000 a year. So access and opportunity is going to be critical in everything that we do moving forward in this state. When we talk about the wonderful programs going on at Marshall and WVU and at West Virginia State University, we also have to make sure that we're working stronger with our K-12 partners, and that we are creating the opportunity for our students and our faculty and us to use our research as 3 research institutions on how we close that achievement gap at that 3rd and 4th grade level. How do we start putting those wraparound services around our communities to where those young people see that they have hope and a pathway to get to one of these institutions, or maybe start off at a 2-year institution and then get to us. I think there are a lot of great opportunities, and my hope is that we'll talk about all of those outside of the wonderful things that we're all doing. But I'm always driven by, and this is what I tell my team at State, if we do not make a way for our students to get to us, and if we do not create that type of environment that is so nurturing, that even that student that is not as academically prepared as we want, because the other piece of this, as we talk throughout this evening, is that we have to be mindful that as we talk about brain drain of our state, we also have to be mindful of how brain drain occurs within the state. And if all of our energy and all of our focus is in Charleston and in the northern part of our state and the eastern panhandle, then the southern part of the state, they will leave those counties to look for better opportunities. And those counties begin to dry up. And what happens to those individuals who don't have the ability to move or to go and look for greater opportunities? So as institutions of higher learning, that's why it is important that we talk about the actual diversity of opportunity and the diversity of our institutions, not in race, but in size and geographic location and opportunity. All these things are important when we start talking about how do we move our state, how do we innovate, how do we get closer to industry, and all of those important facets that's going to continue to help West Virginia climb. So I'll stop there and we'll open it up for questions if you.
Yeah, I'm going to open it up for questions. Take a few minutes right now to maybe write down some of the questions you want to ask. I'm going to ask the first question to give you a little more time to look at it. And I'm going to start by just telling a quick story. I was taking my daughter one time to one of these craft places, and I was the president of West Liberty, and we were checking out. West Liberty historically is a teachers college, so we have a lot of teachers, and we're checking out, and there's a little girl there, and I asked her, I said, "Do you go to college?" And she said, "Yes." And I said, "What are you in?" And she said, "I'm in education." And I naturally assumed she went to West Liberty, and I asked her where she went to school. She said, "Western Governors University." I bring up that point because when I got out of high school in 1971, and I know what you're thinking, you certainly don't look that old, but but when I got out in 1971, seriously, most of my friends, you had basically 2 options. If you wanted to go to a small school, you went to West Liberty. You wanted to go to a big school, you went to WVU, because we were in the north, and that's kind of where you went. But things have changed so much. The academic marketplace has become so highly competitive. And what I would like to ask the panel is, what can we do as a group of public universities to kind of move us forward, give us that advantage so that we can become as competitive, if not more competitive, in the academic marketplace?
Well, I'm going to, first of all, you really don't look that old. But you are old. So
Remember what we were thinking.
yeah, I know that you guys were thinking it, but I said it.
Remember who gets the last word up here, okay?
Yeah, that's my lot in life. But there you go. So anyway, the way that I think about it, about higher education, is that first of all, I think I like to think about the fact that we need to really focus on education as being a pre-K through life concept. We all know that not everyone should go to our institutions, but we do know that education is important. Well, the thing that strikes me is that right now we have over 20,000 jobs in this state for which we do not have skilled workers. So we should all be concerned about that, number one. Number two is the fact that if they're right about AI and the impact it's going to have, the 3 of us are engaged in teaching obsolescence, because 80% of the jobs that we are now training people for will not exist in 15 or 20 years. So the question is this: how do we become relevant again? And I think the way that we do it and I really appreciate that question, Rob. I think the way that we do it is that we really, all three of us and all of us in higher education, that we really commit to looking, asking the question 20 years from now, what will the world look like, and what do we need to do to make certain that the economy and the social structure and the creativity and the energy in this state is meeting those needs, and that means that we have to engage in fundamental reform. Jerry knows this because I've said this to him a couple of times, but I really believe that higher education is structured for the past and not for the future, and so I think that really is our major challenge: is how do we work together to restructure ourselves so that we really do have this kind of conceptual, organic system that will serve the people 20 years from now, but we're doing it right now.
I think we need to be looking at more opportunities to serve students in different ways in college, and certainly I think micro-credentials is a way that we're exploring at Marshall. That is just a couple of courses, or maybe even not a 4-credit course that a student could take and get some type of certification or some confirmation of their ability to do something in a certain area. I think we also need to look at more online opportunities for our students. And I think we need to teach our students to be entrepreneurial. And we've certainly, by working with Brad Smith, we're going to be integrating design thinking into our curriculum so that every freshman gets a exposure to design thinking. I think, the jobs that are going to be out there in the future, students are going to have to be creative and reinvent themselves as they go along, and we're going to teach them at our institutions of higher learning how to be creative, how to be lifelong learners, how to adapt to those changes in the job market. We know that students now, or graduates now, change jobs 5 and 6 times. It may be even more in the future, but giving them those critical thinking skills, giving them the ability to be entrepreneurial and to be creative, I think will make them competitive in the environment where AI is going to be more of a force, and also the machine learning and all of the things that will come into play in the next 10 to 20 years. So I think we've got to look at different ways of teaching them, and we've got to teach them to be adaptive. Anthony?
No, I agree. Those are some excellent points. I just, 4 things that I've just jotted down here as we were talking. Stackable credentials, pretty much what you were also talking about, Jerry, is going to be critical. We in higher education can no longer graduate just a student in business. That student has to have some interface with AI or coding. That's the type of student that our market is looking for today. That's going to help us stay both relevant and competitive. I also think that we have to continue to help industry solve problems. How do we take the actual research that we're doing and turn that into translational research so that it is problem solving, helping industry move forward? Again, that I think also creates an opportunity for us to continue to be relevant and competitive. We also have to look at how we help our students be more career ready, where industry does not have to go back and invest so much time and energy in making sure that our students can do what it is that they need them to do. That also requires and could also foster us being more competitive and being more relevant, is that we work with industry closer to build 21st century, with industry to build 21st century curriculum that our students need. They're the experts who can help us indicate and understand where their industry is headed. And lastly, I'll say is that somewhere I think the tail started wagging the dog here, but we in higher education need to get back to helping society understand what an educated person looks like and what an educated person can do. I think that over the last several decades, because everything around us has been moving so quickly, we've been trying to play catch up. And so society has said, well, you have an accountability issue because you're not producing what we want. We need you to produce this, go do that, now go do this, and so forth. And we've gotten out of, I think, the actual lead of crafting that narrative of this is what an educated person looks like. This is what they can do. This is how valuable they are to our society. So those are some of the things I think that are critical in our ability to remain both relevant and competitive as we move into the future.
I'll add too that I think as research institutions we have an advantage because we can bring to bear those internships and experiences at our institutions that the non-research institutions don't have.
Right.
So we have the ability to connect with industry and to connect with those meaningful experiences that student needs to have when they leave the university.
You know, one thing, Anthony, that what you said reminds me, and that is the fact that when you talk about the educated citizen, you know, we often struggle, and I think we'd all admit it up here. We often struggle with what is the role of the humanities and the social sciences.
Right.
And that's my whole point.
When we're moving toward this very dynamic machine learning world.
Right.
I actually think that the social sciences, the humanities, particularly the humanities, are going to become much more relevant and should be relevant because in the end, if indeed my proposition is true that we're all in the obsolescent mode, the one thing that will not be obsolescent is the ability to think
right.
and to read and to write and to create.
Right.
And those things, I think, have lost their way, and we need to get recentered on those.
I'm just going to close with a couple of comments because I love this discussion, and you know, we've had these types of discussions before. Let me ask you something in here. How many of you all had language in college? Raise your hand. How many of you had language? Let's see. How many of you can speak it fluently? That's trying to make my point. Part of the problem, I think part of the problem we have in higher education and education in general is that education, getting a credential is based upon seat time. How long did you sit in the seat? You know, it's always been one of the most amazing facts to me. Amazing. Just think about this in college. No matter what you take, it could be accounting, social work, social studies, no matter what it is, everything you need to learn can be learned 3 hours a week for 15 weeks. Does this seem odd? Because what we do is, at the end of 15 weeks, the bell rings and whatever you've learned, and then you kind of move on. And I think one of the things we're going to have to look at down the road, and a lot of online competitive institutions are starting to do this, is we've got to start looking more toward mastery. We've got to look more toward having our students making sure they master the subject matter. Let's face it, the 3 hours a week for 15 weeks, 120 credit hours to graduate, that's something that's very convenient for the institutions. It's very convenient for us. But it doesn't necessarily best serve all of our students. And if we're going to serve all of our students and bring everybody up, I think one of the areas that we have to start looking at is mastering the subject matter. Some of the things they mentioned is exactly right. Critical thinking, creative thinking, problem solving, all of those types of things. They're very subjective. Sometimes they're very hard to quantify. But the fact is, I think we're going to have to start doing that if we want to we produce wonderful students now. But if we want to get down so that we're producing all of our students with those types of skills, I think it's something that needs to be focused on. Let me take questions now from the audience. I'm holding you here for another 40 minutes, so you might as well do it. Okay, well then I'll ask another question.
Here we go.
Like going, oh, there you go. Okay.
So, gentlemen, maybe more than ever, what we'd like to do, what your institutions are looked to as drivers of the economy, as opposed to simply research institutions or teaching institutions. Can you talk about the evolution of your faculty recruitment and promotion, and even tenure process, and the extent to which, if at all, you can align that with the expectation now that faculty member in today's economy, in your institutions in particular, will be looking to do more than simply research and publish, but rather make contributions that can actually drive the economy?
Yeah, Mr. Speaker, I'll try that one because I think that, and I alluded to this earlier, first of all, I think universities are organized the wrong way. I think that we're organized vertically or vertically, and we need to be organized horizontally. We need to get out of these. There's a tyranny of the department and the college, tyranny, the gerontocracy, I might note, for me. We need to really, universities are sort of divided this way, that those above 50 want the universities to be the way that they remember them.
Right.
Those below 40 want to engage in change. The problem is those above 50 control the narrative, and those below 40 are put through a narrative that they don't want to be put through. So what we have to do is we have to change the structure of universities and colleges. We'd be much better if we organized around institute centers, working groups, and ideas, and get away from these vertical structures. Number two is that, and this is really to your point, we really do need to have multiple roads to salvation. The notion of just having one way to get into the business of higher education is really obsolete. In our instance at the university, I'm really a strong proponent, and we're moving aggressively toward this to make certain that we have a number of ways to reward and recognize people. Tenure, non-tenure. I think that tenure is a symbolic issue anyway, and I think really what we have to do is we have to say, if you really teach well, we're going to give you the opportunity to do that. I'll think about my department of English. In that department, there are people who are going to write the great American novel. There are people who love to teach, and there are people who shouldn't see students. And so what we really do need to do is we need to say each of those have a major contribution to make, and let's let them contribute by rewarding them for doing what they really do well. So I really think that we need to have a number of tracks on the innovation side. I'm planning a trip to go to the University of Waterloo, which is a small university in Canada, because I was meeting with a group of entrepreneurs, and every one of them said the most innovative institution they've seen in the world is at Waterloo, because of the fact that they just have this open platform where people who come and they innovate and create, they're rewarded for doing that, and they have access to those resources that they create. And that is the way that we're going to change the structure and function of universities. I do not believe in strategic planning, because I think that it's a myth. I think the truth of the matter is that we need to have strategic action, immediate response, and universities have got to stop being elephants and become ballerinas. So you're right on point. It just takes a while for us to get there, I think.
I would agree with everything that Gordon said, and the faculty that we're hiring today are very different than the ones that are the more mature faculty. They are more innovative. They're being trained differently than we were trained, so I think it will happen, but it's not a rapid process in higher education, unfortunately. But there are the chances for our business schools, our engineering schools, some of our science-oriented majors to very quickly adapt to the needs out in the business community.
Yeah, I mean, you all, I think, hit on all the points, the excellent points. What I would just add is that there is a trend moving through higher education where new faculty members are coming in and are pushing back on the tenure track piece. They are saying, I want to teach, that's what I want to do, that's what I am good at, that's what I want to focus on. So what you see is that some institutions are moving to term contracts, right? That takes the actual research piece out of the equation, because some faculty are very disgruntled with the actual politicizing of the tenure piece. So I do all of this work for 5 years. I do all of this research, and if I have a disagreement with my chair or my dean, then my career at this institution basically is over, right? And so people struggle with that. The other piece I think that's important is the culture of the institution drives what your actual question is, right? Is what are the expectations of the faculty coming in? Is it just do research? Are you teaching? Are you doing your service? There's no engagement with students. And just like Gordon said, Some folks we don't want interfacing with students. That's just the reality of things. And so the actual culture of the institution, a shift in how doctoral students are coming out of their programs and how they want to have some more control over their careers, I think is changing some of that on its own, but the institutional leadership and the institutions have to play a role in continuing to foster whatever culture it is that they're trying to have at their respective schools.
If I could just add a coda to that, which is this, that we need to be rewarding the creative folks.
Sure.
And as a R1 institution, as a research institution, I am very committed to having people discover the cure for cancer and rewarding them for doing that, or discover a variety of other things. The thing that I think that what I'm at least talking about is the fact that we need to take those folks and reward them for doing that, but we need to make certain that and I believe this is what the speaker's really alluding to, is we really need to make certain that the people in McDowell County and other places have access to those ideas. As you know, and I've been president of several of those institutions, they take just great pride in just doing what they do, and they never want to get outside of their bubble.
That's right.
And that's important, but the research side of the universities are enormously important. We just need to escalate it and make certain that it's relevant and make certain that it's available almost immediately. I think this, Jerry, I think if the changing nature of higher education is evolution rather than revolution, I think we may evolve ourselves right out of business.
Next question. Yes.
The answer is yes.
Yes.
And in fact, I think the notion, Carolyn, I think the notion of us teaching people how to think and express that thinking, I think that is a continuous lost art. You take a look at our students. I watched them the other day. There are 4 kids walking in front of my office. They obviously were friends, but they were all on their phones, doing, messing with their thumbs. And I mean, it just strikes me as what we've lost. We've lost the art of communicating. And when we do communicate, we communicate in symbols that I don't understand. And so I think that notion, you can be very forward thinking, but there's a fundamental nature that we need to constantly maintain.
So to your point, and I'll just add on this, when I talk to my incoming freshmen, I always tell them that I don't care how advanced technology becomes. I don't care what it does to advance our society, our life, our world. It will never supplant human interaction, right? And we have a responsibility to make sure that when we talk about those soft skills, those skills that are going to make a difference in a person's life, speech, speaking, public speaking, that's one of those skills. We often hear, or I have been in situations where in my first year experience class, I am reading papers by students and they are writing the way they talk. And they've yet to understand there's a difference, right? So we have a responsibility to help them with those things, and speech and public speaking is one of those factors that I think go a very long way in helping someone throughout their life and their career.
Let me ask y'all a question to kind of follow up on this. At my last institution, of course, all students take English 101, English 102, which is composition. And the problem we had was honestly finding qualified instructors who had backgrounds in grammar and composition. We had English professors, but quite frankly, all of their backgrounds were all in literature, which is fine. but they really didn't have any emphasis on that type of communication. Is that one of the problems we have? Is we're just not producing enough professors that can focus on those areas?
We've not had that problem.
I should have come down there and
Yeah.
stole a couple.
We have plenty of English professors.
No, we have a lot of. Oh, I had a
And they
lot
all
of.
can teach composition.
No, where this came from was people in the science college, or science college. They would come to me and said, these kids are coming out of English 101 and 102 and they can't write. And when we looked into it, we found that a lot of it was because we didn't have faculty with backgrounds in composition and grammar. It was mostly in literature.
Again, I mean, higher ed can't solve all the problems, right?
Well, no, that's what you're here for.
but I say that because I put the comma in the but, which means something else is coming on the other side. We have to, and I said this earlier, we have incredible faculty, we have amazing students, we have groundbreaking research. We have to have a stronger partnership with K through 12. For us in higher education to be blindsided by what's coming down the pike, that's our fault, right? So when higher ed was blindsided by the growth of students who were coming into our institutions with mental health challenges, that's because we didn't have a partnership with K through 12 and didn't know what was coming down the pike. When students are entering our institutions and they need a little more academic support and academic preparation, that's not something that happened overnight, right? That has been coming our way for years, and yet we've either not paid attention purposefully or subconsciously, but now then we're stuck to deal with some of these challenges, and greater accountability is saying, why can't you in higher ed do something? Why can't you help this young man or woman get out? Why can't you turn them around and so forth? There's a lot of work that happened before they got to our front door. But I think we have to look at how we can partner better and work through some of those challenges. We can't fix all of those challenges.
Well,
but I think we can do something.
Yeah, well, certainly we can. In fact, I think that one of the things that has happened is sort of been the abrogation all along the line. In some ways, sometimes we've turned universities into Red Cross units.
Yeah.
We're supposed to solve societal ills. When societal ills were rested on our front door because of the fact that other people weren't solving them.
That's right.
That means we need to collaborate. That means we need to cooperate. But also, we don't need to constantly take on the role of others. We
Right.
need to be very progressive about our own
And that
calling
is-
the role. That's the reason I think it's a continuum.
It is. So to your point, Gordon, is how do we help others start solving those problems early on? Not that we need to come out of the phone booth, right, and play Superman and solve every issue, but how do we then take our graduates and our community and say, this is an issue. Let us help you identify how to solve it. Now you go solve it. And through our research or innovation or whatever it may be, that's my point. Is not for us to step in and start making the house, but let's show them how to build it and then move forward.
Next question. Yeah.
So you're talking about AI and so forth in the future. What do you see the role of education in the future? Is it going to be more possibly back in the future like it was at Harvard in the 1600s, where you had a strong liberal education that taught you how to think? Because 20 years from now, who knows, will accounting be there? Will certain management processes be there? What we're teaching students now may be very well antiquated within the next 5 years. So do you see the role of education in the future as being more back to the future as it was with Harvard and some of the schools in the earlier years of America?
Well, we all agree that Harvard is backwards, but I think that that's true.
Stuck in the past?
Yeah, it's stuck in the past. Well, I think when I said that we need to look out 20 years and then reverse engineer the way that we really are engaging in education, I do believe that what you've heard from us is there are certain fundamental fundamental skills, if you want to use that word, our ability to think and create. I think that that's important. But I do think that we need to move back to some fundamentals. Just the writing, reading, the trivium, the quadrivium that we need to try to get at. But no, we need to look to those issues in order to be able to look to the future. That would be the way that I think about it.
Well, and I would say that all students in the future are going to have to be able to function in a technological society, and part of that would be the basics in terms of knowing the humanities and the critical thinking skills, but they're going to have a certain level of technology knowledge. And, we see students coming in knowing the smartphones probably better than we do, so they're picking that up along the way, but we're going to have to reinforce that and help them be adaptive in the future. Lots of the things I learned in college are no longer applicable, and I've taught myself stuff since I've been in college. So, being a lifelong learner is going to be very important in a very changing world in the future.
Well said.
Next question, right here.
Here we go.
Yes,
Charlotte.
yeah. Actually, if you remember, you asked me out in the hallway. You told me you had a question, so go ahead.
Creative economy, yes.
Yeah, well,
Yeah,
Charlie,
brain drain.
I think we all recognize the brain drain. We had to do two things. One, and I'm not going to give my old joke about building a wall around West Virginia. I think that we do need to keep our young people here, and it's and the way that we do it is that we start rewarding this kind of innovation and creativity and creating places where that can take place. And it takes a place around universities, as a matter of fact. And number two, we need to make West Virginia cool. Number three is we need to diversify our economy. You know, here we welcome 50,000 scouts from around the world, 40%, by the way, of whom are women, from 153 countries. And all of a sudden, they were here and they realized that this was really a very interesting and wonderful place. Our outdoor recreation, all the other kinds of things. We've exported coal, oil, gas, and talent. And all four of those were a mistake in many ways. And so we need to reverse that. Now, the good thing is the fact that maybe we have raced to the bottom, but that means that we have an opportunity to really innovate and move forward in ways that a lot of other places can't, because they're kind of stuck where they are, in my view.
I think we've got to talk to millennials and ask them the sorts of things that would attract them to the state, and start focusing on creating an environment that's attractive to young people. Charlie and I have talked about this before. We're not the best people to figure out what's attractive to someone who's 20 to 30 years old. We need to be talking to those individuals and creating the climate and the environment in the state that will attract people here. Part of that's jobs, but part of it's culture, and that is changing the culture to make it an attractive culture so that they would pick, you know, Huntington or Charleston or Morgantown over Palo Alto or San Francisco. And, you know, we've just got to focus on that.
Yeah, you know, there is a lot of evidence. So, I mean, the trend is moving. People are tired of stumbling over folks in San Francisco and a variety of other things. And there is a huge movement toward moving to middle-sized, creative cities. And that's our opportunity. And that's our opportunity. And that's where we really need to put our time and our emphasis. And the trend is with us now on that one.
It is. And to your point, when you talk about creativity, as we talk about some of the things that are moving us into that direction, I think it's also important that we have to, as a state, look at how welcoming are we. And that comes in the form of messaging. That comes in the form of when visitors come here, like with the Scouts and all of these other people. Diversity brings creativity.
Absolutely.
Right? So we need to look at our state and say, what more can we do to brand ourselves in a way that is welcoming, not just from a race and ethnicity standpoint, but across the board. It's West Virginia is a place, a great place, for you to come, live, socialize, grow, create, innovate, all of these wonderful things. How do we put that in a package? Now, let me throw a little plug in here for higher education. If we take a page out of North Carolina's book, you would use higher education as part of the cornerstone to bring that talent to the state and to help people remain in the state, right? Because that's what North Carolina did. And that's why when you talk about systems, they have arguably one of, if not the best system of higher education in the nation, or at least some people think so. So when you start listing off those schools and you have Research Triangle Park and you have all of these individuals moving there, that just didn't happen by happenstance. There was for lack of your not liking the term, Gordon, there was a strategic plan.
That goes all the way back to the 1960s with Terry Sanford.
Right.
And
so listen, this is what we're trying to become, to the question in your back, what are we going to look like in the future? Whatever we're going to look like, it's going to center around education, because industry and people are not going to move to a state where the K through 12 system is at the bottom and the higher education system is in the middle, right? That's not where companies, industry, and people are going to want to come. So how do we make West Virginia sexy? That's up for us and a lot of folks outside of this room to figure out, but we better get busy doing it.
Exactly.
I can take one more question.
100%.
One more? Yes.
No.
Anthony?
Well,
No.
nobody would disagree with that.
No,
up
nobody
there.
would disagree.
Yeah.
Sure. So how do we make sure they're, sure, so Jerry and I just left an actual presentation where WVU, Marshall,
University of
University of Charleston,
We're
are all talking
collaborating.
about partnering, collaborating, real work that is being done right now through the business schools, other aspects and so forth. Your part about the whole liberal arts piece and the arts, that is important. I mean, we have gotten to the point where STEM has really taken the focus of many of our conversations, and I'll tell you that when you look at some of the greatest scientists throughout history, right, they've had a art backdrop. So what I don't want us to do in the state within higher education or any other landscape is to have this mindset that it has to be this or this. It can be this and this, right? And so all of us are going to have to do the heavy lifting, and that's why we talked earlier about the actual diversity of our institutions, and the beauty of that is that some students want that. Some students want 30,000. Some students want 14,000. At West Virginia State University, we believe in something called in loco parentis, which is Latin for in place of the parent. That is the hallmark of our institution, and that's what we were founded on. So how do we blend all of those things together to have the most enriching educational experience for our students and those who come out of the state into the state to get educated and they fall in love with it? That's what I meant earlier when I said at the national level, we have to have such a brand within higher education, across higher education, 2-year, private, public, 4-year, and so forth, that people fall in love with what we're doing and that our education is second to none and people want to come and be a part of this. But your point is well taken, and please note that private higher education is not being left out of the conversation. It is extremely valuable to what we're trying to accomplish.
And most of us up here would welcome collaboration.
Yeah, absolutely. I mean, I think Dr. Rodenberg knows that I admire exactly what she is doing. I think the challenge of private education is extraordinary. I think if we strip everything away, it really is extraordinary. I shared with her that about 6 or 7 years ago, I chaired a commission on the future of the American University for the ACE, for the American Council on Education. And it didn't take very long to figure out that the most threatened institutions in this country are the small, tuition-driven, liberal arts institutions. But we also have those in the public sector, but more in the private sector. And so the question is, how do we make certain that those institutions continue to thrive, not survive, but thrive? Because I think the great strength of the American higher education system is our diversity. You have large and small and public and private and Mormon and Catholic. You have all these institutions. And the minute that we move to a federal system, the way that they have, it's interesting. In Japan, and for example, they have one of the highest attainments in the world in their so-called K through 12 system, but then they go into their universities, which are federal, and everyone is sort of a McDonald's hamburgers. They kind of fall off the cliff in terms of innovation and creativity. And so I think that it's important. But also, I believe that the private institutions have to face the reality that they have priced themselves out of the market unless you think about partnering with the public institutions, about finding niches and pathways and 2+2 programs, and all of that I think is incredibly important because there is a wonderful place for the small, highly disciplined liberal arts institutions, but some way or other we're going to have to think of a way to make certain that there is a positive collaboration that allows survival and thriving, and I think that that's where we have not really put a lot of our energy.
Okay, thank you very much.
Well, I haven't taken a look at the micro scale, but I have looked at it at the macro scale, and the pricing policies have really been decimated. The private institutions, they're closing every day. I mean, that's the point. The point is the fact that we've got to get back to figuring out why that is. It's not that that's good. It's that is bad, and we can argue the data all day long, but unless people flow toward those institutions more than they are, they do have a serious life-threatening problem, and that's the issue, I think.
That's going to have to be the last word because we've run out of time. Let's give our panel a nice round of applause for. The chamber has given me some housekeeping to do for the rest of the evening. The first thing that they've given me is the registration desk closes at 5 o'clock, so if you haven't already picked up your Fiesta ware and gotten your name tag and other information, you're out of luck. The Business Summit evening reception is at 6 o'clock, which is about 7 minutes on the Colonial Terrace, and then dinner is on your own. We will begin early tomorrow with breakfast in the Colonial Hall at 7:45, and our program will start promptly at 8 o'clock. On behalf of Bluefield State College, let me thank all of you for coming here today. We certainly appreciate it.